Okay, reading from chapter 4, section C, other uses. Other uses of specific conduct. Conduct on other specific occasions cannot be character evidence, but may support state of mind, etc. Permissible purposes, not propensity. Intent. See Beecham. Motive. See Boyd. Finance. Cocaine trafficking. Opportunity. See Dijon uttering. Plan and intent. See Lewis. Post office burglary. Intent. See Crocker as driver for conspiracy to rob banks. Modus operandi. See Dossie for bank robbery. Identity and intent. See U.S. versus Davis. Kilo of cocaine also flawed and reversed. Prior conviction inadmissible to show intent. And see U.S. v. So these are all for intent, and I'm just speaking to some of the cases that I guess I read. Hayward, Morrison, and it gives years. I have to type it because dictation just doesn't like that. Hayward is 2002. Okay. Morrison, 1989. Santini, 2011. See Enriquez v. U.S. 1963. See U.S. v. Butler. 1997. See U.S. v. Logan. 1997. See U.S. v. Gaddison. 1993. We'll fill in later if I brief those cases, which I probably did. Advisory Committee Note to 1991 Amendment to FRE 404. FRE 404. Most cited. Critical to prosecution. Not often used by defendant. Pre-trial notice requirement in criminal cases and is intended to reduce surprise and promote early resolution on the issue of admissibility. Treatise opinion that difference between extrinsic acts for character and not for character are illusory, and non-character extrinsic evidence entails assumptions on tendencies and disposition. Mens rea rising in admissibility. UK looking to remove character exception entirely. Morris opinion regarding 404B. Character exception, if overcome by intent, modus operandi, plan, should still be limited by propensity. So they are not character inferences. Rothstein treatise. Behavioral capacity because narrows suspect pool. Highly probative because for certain offenses that are against moral code of vast number of people, i.e. rape, bank robbery, suggests prima facie treatment of extrinsic evidence for mens rea, identity, Baganic opinion. Requisite proof. Difficulty allowing charged misconduct to be proven with evidence of uncharged misconduct that is itself contested. Character and habit. FRE 406, CEC section 1104, 5. Character. Generalized description of one's disposition in respect to a general trait, honesty, integrity, temperance, peacefulness, habit. One's regular response to a repeated specific situation, i.e., regular practice of meeting a particular kind of situation with specific kind of conduct, and can become semi-automatic or routine practice of an organization. Religious practices lend themselves to characterization in variable regularity. Multiplied and maintained, but not specific sampling, measure. Report of Judiciary Committee. Rule omits how to enter evidence because it is intended to be case by case. Opinion, okay, but not unsanctioned. Case number 91. Skip cases. So right now I'm paging through cases to get to the next book notes, which I've reached. Mangler opinion. Yeah. Mangler opinion. Non-volitional or semi-automatic nature of habit. Probability theory. Regular response to a specific situation. Regarding psychological theories of habit, Pavlovian, unconsciously mechanical, sexual assault and child molestation, rape shield statutes, federal and state, curtail defendants' invocation of victim character evidence to prove consent, because harassment, discourage reporting offense, and greatly overvalued by juries. However, prosecution and plaintiff can enter defendant character evidence to case in chief. Character of the victim. Historically, highly probative, admitted even when no issue of consent, evidence overvalued, misused, distracting. Wigmore Treaties, FRE 412, CEC 1103, C. Wigmore offers auxiliary policy because character of rape claimant's chastity is relevant to issue of case, considerable probative value for consent, previous voluntary habits, natural result of the mind, are for example, consistent, natural operation of her propensities to rebut inference of necessity for violence. For example, repugnant. Often character is conceded but only admissible on issue of consent. Remarks of Representative Elizabeth Holtzman, proponent of FRE 412. Protection against injustice inequity because plaintiff experiences humiliating cross-examination on morality that distracts from the defendant's crime, innocence, or guilt. Advisory Committee Note to 1994 Amendments to FRE 412. See note card. FRE. Applies to civil and criminal allegations of sexual misconduct, kidnap, and sometimes harassment based on balancing test. Shift burden from defendant to object and to proponent to demonstrate admissibility. Raises threshold for admission. Harm to victim on scale alongside prejudice to defendant. Bars mode of dress, speech, or lifestyle that has sexual connotation from fact finder. Includes behavior of mind. Bars substantive evidence and impeachment evidence. On dress, etc. On. Except not applicable to a third-party witness. Character of defendant. Regarding prior misconduct and sexual assault and child molestation. FRE 413 415. CEC 1108 1109. Molinary remarks. Prior sex misconduct. Child molestation. Highly probative. 15 to 20 years ago still, because sexual or sadomasochism but does not exist in ordinary persons, for example, limits candidate pool and heightens probability of truth. In contrast with Rule 404B, character and propensity prohibition, the new rules for sex offenses, admission, and consideration for uncharged offenses for its bearing on any matter in which it is relevant, including propensity to commit sexual assault or child molestation. ... Because probative value. Probative. So just skip through a bunch of cases and get to those cases. To the next book notes, which going to be a number. Report of Judicial Conference of the U.S. on the admission of character evidence in certain sexual misconduct cases, 1995. Violent Crime Control and Act of 1994, adding FRE 415, overwhelming number of women's rights organizations, private individual lawyers, scholars, and organizations object, believing the rules are redundant because they're already adequately set forth in rules of evidence, example, FRE 404B, and do adequately safeguard accused of prejudice. Unanimous vote against acts, FRE 413, 415 provisions. Salzburg treaties, act bypassed objections by Judicial Conference, Judicial Conference Advisory Committee, Standing Committee on Rules of Practice and Procedure. Who recommended and reconsideration because volumes of dissenters agreed it was bad policy, but Congress refused. Alternatively, 404 and 405 revised by advisory committee to correct ambiguities and possible constitutional infirmities, but was not adopted. Advisory. .413, 415 became effective July 9, 1985. Duane opinion. Deters from accuracy and integrity of judiciary system. Of adjudication. Contrary to constitutional value determinations. Magnified. Not coincidentally. The possibility of innocent being accused of wrong or wrongfully identified. Wrong. Orstein opinion. Litmus test. Has accused a checkered past. Lifeboat syndrome. Women and children rules should differ. Merger. Infantilization of women. Park opinion. Prior acts should be entered if defendant enters defense of consent. Distinguishes stranger on stranger child rape from consent defense rape. Chapter 7. Impeachment and rehabilitation evidence. Intro. Evidence qualifies as impeachment if it is relevant because it suggests that a certain witness lacks credibility and therefore that his or her testimony should be disregarded. Evidence qualified as rehabilitation if it is relevant because it rebuts impeachment evidence. Distinguished from cross-examination and direct. McCormick on evidence, FRE 607, 806, CEC 780, 785, 1202. 5 main modes of attack on witness credibility. Proof of prior inconsistent statement. Witness bias. Kinship, hostility to opposed party, pecuniary interest. Toward. Character attack. Religious belief, off limits. Defect of the witness ability. Capacity to observe, remember, recount. Remember, recount. Specific contradiction. Other witness. Document. Physical evidence. Procedure Article 4 of FRE and Analytic Framework, FRE 401, 3. Intrinsic. On stand during cross-examination, but must be good faith basis for inquiry. Extrinsic. By defense's case in chief. (401), 403, by a federal judge. Send this section to suspense. Character for truthfulness. Character for truthfulness. Generally prohibited. Person likely acted in conformance with proclivity to lie. (404A), traditional exception to character prohibition. In general, 404A prohibits opinion. 609, conviction of a crime. 403, balance probative value to prejudicial effect. Confusion. 611, harassment, embarrassment. Advisory Committee note to FRE 610. You may ask religious affiliation on redirect to salvage or rehabilitate character, witness character. Credibility. Prior criminal convictions. If one's nature is to be deceitful rather than lie. Admissible and inadmissible convictions. All right, so that just leaves the cases that I have to brief. And in total, that I recall being 15. In order to be finished with tonight's assignment, for the record, I'm on page 41. And I'm halfway done outlining the book.